Hi, this is Brad Aldrich, and this week's topic is probate and estate planning. The probate and estate planning field covers three main areas. The first is probating of an estate. This is where an individual has deceased, and one of typically their heirs or beneficiaries seeks to have their estate probated in the probate court, which is in the county where the deceased person resided. And you're asking a probate judge to determine where the assets of that estate need to go. And one of the main reasons for this is that a deceased person, can no longer sign off on a deed to a piece of real estate. They no longer can transfer assets out of a bank account, etc. And a probate judge can actually sign orders to make sure that that happens. Probate judge can also make determinations as to who gets the assets of the estate in case that there is some type of a controversy over heirs or beneficiaries. The second main area is estate planning, and this is where an individual or a couple would want to put forth certain documents to be in place upon their death or disability. The three main components of estate planning are wills, trusts, and powers of attorney. A will is a legal document that sets forth where one's assets are going to be distributed upon their death. In the will, you can also set out other things such as funeral arrangements, whether you want to be cremated or buried, who is going to be the conservator of your minor children in the event that you or surviving spouse are not around. There's also the trust, and the trust is a separate legal entity that you create. You transfer assets into the name of the trust, and then that trust survives beyond your death. And then there would be a successor trustee which steps in and is able to take control over the assets of that trust and make sure that the wishes of the person who created the trust are upheld, such as making sure minor children are taken care of, making sure assets get what they need to be. A trust can be used to often avoid probate court. The third aspect of estate planning is powers of attorney, and that can be legal documents that set forth a third party who has control over certain parts of your life in the event that you are disabled. If you are on a coma or under some other type of disability that makes you unable to make decisions for yourself, this third party would be given the power to make medical or financial decisions on your behalf. The third aspect of probate and estate planning is where one may seek to have a guardianship or a conservatorship placed over another individual. You would file suit in probate court and have a probate judge determine whether an elderly family member or perhaps a minor or someone else who is legally incompetent, you'd have that judge decide whether it is appropriate for a guardian or conservatorship over that individual. If you feel that you would like some information in any of these areas, please email us and we can provide you with a brochure, or visit our website at aldrichlegalservices.com, or simply call our office and set up a free consultation.